Judge, before you this morning is case number 24-CR-574, captioned State of Ohio versus Mackay v. Tucker. Your Honor, we were last before the court on January 10th of 2025. At that time, the defendant entered a plea of guilty to 2 counts. The first charge was improper handling of a firearm in a motor vehicle, a felony of the 4th degree in violation of ORC 2923.16. Second charge was a charge of receiving stolen property, that being a firearm, violation of ORC 2913.51. The defendant is present today in court with counsel, Ms. Smith. We are here for purposes of sentence. Prior to coming to court today, Judge, several reports have been completed and submitted for court review. And according to the Adult Probation Department, the defendant does have 21 days of jail time credit.
Give me 1 second, please. How did you get your 21? Oh, can you come up here, Jennifer? Do you have the time initially? Because this shows he was arrested on the day of the incident, right?
He was, Your Honor.
Which was the 25th. Well, before we go any further, I was looking at the credit. I know we talked in chambers, it was 21 days, I think. I don't even know if we talked about it in chambers, but the prosecutor just mentioned that. I seem to have more here. I don't know if you looked at it or not. The jail list shows he was booked in on the 23rd of January. Does that sound right? Or you don't?
I think it was the 22nd, but it might have been the 23rd because they booked me in a little late.
Well, jail list has a 23rd. So that until now is 19 days. 3, 4, 5, 6, 7, 8, 9, 10, 11. Today's the 10th, right? So through today, that'd be 19 days. And then if he was arrested on April 25th, the Willoughby bindover shows he didn't post his bond until May 2nd.
Did you spend a week?
No, I bonded right out the next day.
No, I'm confused.
Your Honor, I believe all of the dates on the Willoughby, from May 7th through 10th on the Willoughby docket are incorrect. The complaint was filed well before May 10th as well. The complaint was filed on
I
April
mean,
26th.
with what Mr. Tucker said, that's consistent with what 21 days then.
Right.
Okay. And if I look at the actual bond paperwork, it says he was released on the 26th.
You
So
said
that, sorry?
I was in jail on the 25th.
Yes.
Complaints were filed on the 26th of April, according to the docket.
I'm sorry?
And all the money was paid on the 26th. The docket dates are just wrong then, okay. So you're right, Jennifer. All right, Ms. Smith, any reason not to proceed with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, on behalf of Mr. Tucker. Mr. Tucker is 21 years old. He's single, has no children, maintains a close relationship with both of his parents. He does live with his mother, stepfather, and brother. He graduated from Richmond Heights High School in 2021, and prior to his arrest on this case, was employed full-time at Cleveland Hopkins Airport. Your Honor, the instant case is the only significant criminal case in Mr. Tucker's history. He did have a minor misdemeanor marijuana ticket in 2022. He has no juvenile adjudications. Your Honor, Mr. Tucker has been in the Lake County Jail since January 2nd.
No.
Sorry.
23rd.
Well, yeah, the 23rd.
Since January 23rd, he has not incurred any institutional infractions. And, Your Honor, Mr. Tucker is young, and on the day of the incident offense had a bad attitude. It's something Mr. Tucker and I have discussed throughout the pendency of his matter. His bad attitude wasn't directed just towards law enforcement. In fact, he was shared the same bad attitude with his father on that day, which I know they have spoken about since. Mr. Tucker has not picked up any additional cases during the pendency of this matter, and the single bond infraction was a positive marijuana test on the date of his change of plea. Your Honor, we do believe that Mr. Tucker is amenable to community control, and one thing that he has been very clear on is this stay in the Lake County Jail outside of his initial arrest on this case has been the only time that Mr. Tucker has spent in jail. And the lesson that he has learned from his bond infraction and being before this court is that the jail is not the place for him, is not a place he ever wants to be again, and he will do whatever is necessary to make sure he doesn't end up there again. For that reason, we would ask the court to impose a period of community control with a mental health evaluation, follow through on recommendations, and then credit for local incarceration time served.
Mr. Tucker, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
Go ahead.
My name is Makai Tucker, Your Honor. I'm not a bad person. I go to work and have fun with my life. I'm a good person at heart. I've never been in any trouble. For a person that has never been in any trouble, these days that I have been in here has mentally kind of wrecked me, but it has actually made me aware of where I want to go in life and what I want to do. When I do get out, I have talked to my parents about going to barber college. That was my dream and goal to do. So as soon as I get out, that is where I'm going to sign up for barber school. Right now I am still, I hopefully, probably are employed at Cleveland Hopkins Airport. I don't have any bad history or anything of the sort of any kind. I'm a good person. I'm big-hearted, and this was a learning lesson that I don't never want to be in this situation again or never.
What'd you learn?
I learned that, I mean, you have to follow rules that are applied to you no matter what. And as me coming to jail and sitting here for these long period of days, like I was talking to the officer before you guys got in here, the 15 days, for a person that never been in jail can feel like 15 years. And it felt that long to me, and it literally humbled me and made me think about life. Like, you have more than just yourself. It's not just about you. I have parents, I have a mother, I have a dad, I have a girlfriend that cares about me, and knowing that I need to do better and for myself, and I do take full accountability for my actions, and knowing that I don't want to be in front of any judge anymore, not just you, any judge. And in my lifetime of my 21 years of living, I've never been in this situation in my life. So this is a stepping stone that I have learned from and greatly learned from. Like, yeah, Makai, you don't want to be in jail. This is not the place for you. The stuff that goes on in jail is just a lot for me. It was a lot for me when I first got in here. I couldn't get it together. I talked to Miss Lisa. Miss Lisa couldn't understand. I couldn't barely talk the way I was so mentally and emotionally torn down from this being in jail. And
You gonna get some help for that?
yeah, when I get out, I'm gonna go talk to somebody.
Doesn't matter what other people think, you know.
I
Doesn't matter what other people think. I know you're concerned with that a little bit, being in jail, and I get that. But once you're out, you got to get that addressed.
Yes, Your Honor.
But go ahead, I interrupted you. I'm sorry. I don't know. I interrupted you. I don't know if you have anything else you wanted to say. I didn't mean to interrupt you.
No, I'm done. But I just want to ask you for a fair chance. You know, I am a great person. I don't have any bad problems. The 7 months that I was out on bond, I got told people don't make it 2 months through bond and actually get through it. I did 7 months, and yes, I did mess up the last moment, but I do take full accountability for it as a young man. And all I ask for you, Judge, is...
Well, what's that all about? What's the truth? Because you told probation that you hadn't used since 2023. Obviously,
Right.
that's not that wasn't true.
So,
Then you've told multiple explanations regarding this marijuana use. I want to know what the truth is.
I don't have an excuse. I don't have an excuse. I take full accountability for that. As me being this young, I do mess up sometimes, but this time me sitting in jail for these, what is it, 21 days?
21 days?
21 days.
19 since your bond's been revoked. Then you had 2 days early on.
So the 19 days was the longest time of my life. It literally tore me down. So, I mean, whatever I have to do to be this great person that I already am mentally and physically, that's what I'm going to do. There's no skips. There's no other way to go about this. This is my life, and I'm the only person that can make the right and wrong steps in life. So with me being in jail, I'm just, after all this, I'm on a narrow path. I've got my thoughts together. It took me a minute to actually go to Barbie school. I was going to go to Barbie school when I graduated. I took a year off, and that year off led to more years than what I was supposedly to do. But now that I'm at this stage in life, I'm fit for getting out and doing my probation or whatever you go with it. But I know that I do want to go to barber school, and I do want to keep working and living my life and keep it going as this good person that I am, Your Honor. I'm not a bad person. I'm a very good person at heart. My heart is very big. I care for my family. I care for myself, and I learned that I don't want to be in jail, and I don't want to step in front of a judge in this type of form or any type of form in any type of way. This was my learning lesson of a person that has never been in jail. This is the hardest time of my life. It literally mentally tore me down. I cried for at least 2 weeks, 3 weeks straight, and all my family could tell me is keep your head up, keep your chin up. That was the hardest thing impossible for me to do at this moment. But Your Honor, I have nothing else to say.
You know, if I put you on probation and if you use marijuana, you're going right back to jail.
I understand
It's not like a normal penalty for marijuana would be what? You get a ticket like you did at one time in the past. I can't remember when that was, but maybe pay a $100 fine at the most. You'll immediately, there'll be a warrant arrest issued for you and you'll go to jail.
Yes, Your Honor, I understand. Can I take a seat now?
Yes, you may.
Okay.
Ms. Smith, anything else?
Not at this time, Your Honor.
Mr. Rhoda for the state of Ohio?
Thank you, Judge. As discussed in chambers, the state is recommending community control sanctions, the terms of which to be determined by the court.
Thank you. This court did review the pre-sentence report investigation, the drug and alcohol evaluation, have considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered the letters that I received. I received multiple letters in support of the defendant. I read all of those and have taken those into consideration. I've considered what's been said here today by the defendant himself, his lawyer, the prosecutor, the recommendations. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. For the factors in 2912, nothing stands out factually about the case indicating it's any more or less serious than what normally constitutes the offense. As for recidivism factors, the court finds the defendant did violate the conditions of his bond using marijuana. It's just a factor indicating recidivism is more likely under other relevant factors. There seems to be a marijuana issue. It doesn't relate to the offense at all. We weren't able to get a straight answer from the defendant in regards to the extent of that. He gave multiple explanations regarding his marijuana use. Usually when that happens, it means there's more of an issue there than he's acknowledging. In regards to the offense itself, there's genuine remorse in regards to the offense itself. He gave multiple explanations in regards to this gun as well and why you had this gun. Initially, it was just on the floor of the car, and you put it on, when you got arrested, you put it on your hip. Then you said you had it on your hip the whole time because you were returning it to its rightful owner, and there was something else too. And obviously there was a horrible attitude at the time this happened. As for factors indicating recidivism is less likely, the court notes the defendant has no prior history. One prior marijuana citation, nothing as a juvenile, really nothing else as an adult aside from that. He's led a law-abiding life a significant number of years, basically his entire life. Under 2913B1, the court finds the offense does involve the defender in possession of a firearm that overrides any presumption for probation, permits the court to impose a prison sentence. But at this time, I find prison would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to available community control sanctions. I also find that the defendant is eligible for the first-time offenders program. I'll place him on that. I'm going to put him on community control sanctions for a period of 18 months. First-time offenders program is something that, for people that really have never been involved in the system before, young, and, well, they don't have to be young, I guess. If you're older and you've never been involved, you'd be eligible for that. Normally, someone that first time they come in on a felony charge, they're typically doing 60 to 90 days in jail. Typically, with the first-time offenders program, it's 30 days or less. Period of probation is less than normal usually. Normally, it's at least 2 years. I'm putting you on community control sanctions for 18 months. I'm going to order that you serve 25 days in jail. You have credit for 21 you've already served. You have 4 more days you have to serve, then you'll be released. I'm going to order that you immediately get a drug and alcohol assessment, follow whatever recommendations are being made for any type of counseling or treatment. I also want you to get a mental health evaluation as soon as you can and address some of the issues that you've discussed. You need to do that and follow whatever recommendations they make.
Yes, Your Honor.
They make recommendations for any type of medication that could be beneficial. They need to follow those recommendations as well. I want you to obtain and maintain either full-time employment, full-time education, or some combination of the two. So barber school's fine if it's keeping you busy. I want you being kept busy basically 40 hours a week. And whether that's all work, that's all school, or some combination of the two. But that's what you need to do. Not to possess any firearms. I'm not going to order any specific number of AA meetings. If the assessment, drug and alcohol assessment, says those are recommended, then you'll need to do whatever the recommendation is. If they don't believe those are necessary, then you won't have to. I want you to sign whatever releases though probation needs so that they can contact your providers that are and the people you are seeing, your counselors. Your pay your court costs and supervision fees. I'm going to dismiss the remaining counts of the indictment. Jennifer, anything else I should be considering?
No, thank you, Your Honor.
Lisa, do you have any recommendations that you think I forgot about?
No.
So, Mr. Tucker, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
All right, I need to advise you, if you fail to comply with any of these rules, any of the conditions, I don't know if I said it, but you're not to use any drugs or alcohol, and random urine screens also, and that includes no marijuana use. But if you fail to comply with any of those rules, any of the conditions I've ordered, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated it, it could extend your probation up to 5 years. I could impose more restrictive sanctions against you, which could include local jail time, or I could terminate your probation at that point and send you to prison then. If I did that at that point, it would be 18 months on each of the 2 counts consecutive, so 3 years in prison is what's hanging over your head. You understand that?
Yes, Your Honor.
All right. I will also release bond at this time. Anything else for the record, Ms. Naroda?
Nothing further, Judge.
Ms. Smith?
Not on behalf of Mr. Tucker.
Thank you.
All right.
Motion to terminate was filed, been previously waived probable cause, and we're scheduled for a final hearing at this time. Mr. Watson, in regards to this final hearing, what is the defendant's intention?
Thank you, Your Honor. May it please the court, in talking with my client, she is prepared to waive her final hearing and enter a plea of guilty to the violation, Your Honor.
Ms. Kovat, you have been charged in case 23 CR 1368 with violating the conditions of your community control sanctions. Specifically, there are two alleged violations. The first is a Rule 1 violation, which requires you to obey all local, state, and federal laws. And it is alleged that you were arrested and charged with domestic violence on October 17th of 2024, and you actually pled guilty to that charge in this court. So that's a violation, alleged violation of Rule 1. It's also alleged you violated Rule 11, which requires you to comply with all special conditions set forth by this court on October 17th when you were, in the date of that original arrest and the new charge, you were with Michael Agapi, and you were specifically told by this court that you were not to have any contact with him. So you violated that condition as well. Now, you have the right to have a final hearing on this allegation, which is a hearing where the state would be required to present some evidence to suggest you probably committed these violations. You could have this hearing, but you can also waive the hearing and plead guilty to the violations, I should say. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can go forward on that waiver and your plea, I need to make sure you understand the potential penalties you face if you're found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation and send you to prison. If I did that, it could be anywhere between 6 to 18 months, and I could order that that be served consecutive to whatever sentence I impose on the new case. Do you understand the potential penalties you face if you are found to have violated your community control sanctions?
Yes, sir.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violations?
Waive and plead guilty.
Waive and plead guilty, sir.
Very well, that's the allegation that you violated Rule 1 by having been arrested and ultimately convicted of a new felony while you were on probation. What is your plea to that?
Guilty.
Guilty.
As to the allegation you violated Condition 11 by having contact with Michael Agapi when you were specifically told by this court not to, what is your plea to that?
Guilty.
The court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Watson, in regards to this case as well as the new case, 24 CR, get that up here. 24 CR 1277. Any reason not to proceed to sentencing on both of these cases at this time?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief because I know we were technically just here 6+ months ago with regards to the 23 case. And essentially, this new case is basically the same. It's got the same victim. My client was given clear instructions the last time that she was to have no contact with them. And yet, this past October, she was with them. These two butted heads like they normally do. They're oil and water together. The police were called. In this case, both parties were charged. However, my client has taken responsibility for her actions. She's not only pled just now to the violation, but she also pled guilty to the new case. Your Honor, my client has some mental problems. I mean, she's a good woman that has a lot of issues. And I'm not here. I'm here hat in hand, Your Honor. I'm not here to make excuses for why she was with the victim in this case. But Your Honor, she previously had severe problems with alcohol. She's been sober off of alcohol for several years now. She's been a regular at AA meetings, even with the old case. And I believe off the record in chambers, even probation admitted she was going to AA meetings. She's been dealing with that. At the change of plea for this new case, Your Honor, she indicated to the court that she's on several medications, several of which were for her mental health problems. I mean, she is medicated, but that clearly shows that she does have a lot of issues, Your Honor. I know this court has a lot of discretion this morning as to how it can proceed with sentencing. And I know under most circumstances, most defendants should not even deserve the opportunity to be considered for community control for a matter like this. But I'm asking the court to please consider continuing her on community control on the original case and granting community control in this new case, and not just letting her go free, Your Honor. But, the Public Defender's Office has worked very hard. We have a bed available at the Everett House, and again, I know there were discussions in chambers about this. It's located in Mentor, Ohio. It's a place where my client can stay. They focus specifically with individuals with mental health problems. I think Ms. Kovach would be a perfect fit there, and they would work with her with housing opportunities, continuing that so she gets her medication, seeing psychiatrists, whatever she needs, and then hopefully weaning her off and getting her out on her own. Your Honor, again, I mentioned before, we're here hat in hand. I know in a lot of instances, most courts would not even consider what I'm asking, but I think this is somewhat of a unique situation due to Ms. Kovach's mental health situation. I'm not trying to take away from her culpability because she's pled guilty, but this is a two-way street, Your Honor, with the victim. And again, these two are oil and water, and they're both.
You're not supposed to be with him.
I agree. I agree with the court, Your Honor. I totally agree.
That's not the victim's fault.
And we've conceded that. But I'm asking the court to give Ms. Kovach one last opportunity with whatever strings the court wants to put on. And if she's not going to follow through with what the court provides, obviously, and she knows it, she's got a lot of time over her head. You're going to hear in just a moment from Ms. Kovach. She is extremely remorseful, extremely sorry. And I'm hoping the court will take these factors into consideration. Thank you, Your Honor.
Thank you. Well, Ms. Kovach, you have the right to address the court before you're sentenced. Is there anything you want to say at this time?
Yes, Your Honor. I'm sorry, and there's no excuse for my actions. I know I wasn't supposed to be with Mr. Gappy, and I made that decision on my own, and I lied to not only Jennifer, but to everyone and you, Your Honor. And now I've sat for these days thinking about what I've done and what I said and how I lied when I should have been truthful from the beginning when Jennifer asked me and I wasn't. I was truthful with Mike, whom I told Jennifer just last week.
You were what?
I was truthful with Mike and that
With Mike?
Mr. Gappy, I'm sorry, and that's how I was taught. And
What do you mean you were truthful with him?
Like oil and water, I was truthful with him. How I was taught to, I was used, and we used each other for whatever reason. And we're oil and water. That was written on. I read my discovery, and it's true. And I shouldn't have been with him. He's older. I don't, he used me for whatever reasons. I used him for whatever reasons. I can't justify that. And I lied to everybody. I lied to you, Jennifer. My support system, which is Signature Health, and I need this opportunity to better myself. When they came to see me from Everett, it's like a perfect opportunity. He says that he rescued me because I was in a bad relationship where I was abused, and then I became the abuser. But on two of these domestics, he was also arrested. I'm also a victim as well. And
How many domestic violence convictions do you have?
I believe 4 total. One was with Tony Kudjis that passed away. And I have quit drinking. It will be 4 years ago, July 1st.
Well,
I
that
haven't
apparently wasn't an issue because you have anger issues and you're still
and I completed
assaulting
anger
people.
management, and I got my domestic violence diploma over at the jail, and I've completed other programs. And they focus on all this at Everett, from what I've heard there. They do IOP like 5 to 7 days a week. They do one-on-one. They do a bunch of different things, and I think I need that to help me. Sorry to say, in this aspect, I was belittled for so long. I think so little of myself. That's what I think. And that's a major problem with myself, being a grown woman, but I am mentally ill, and I feel like I was used to that. I was called a retard. And maybe I am. I don't know.
Well, you told me about your interview with Everett House. Why don't you tell me about your interview with NeoCap? How'd you treat those folks?
That's another thing I like to address that was brought to my attention was that to my acknowledgement, the lady was done and said she was done with her questions. I thought she was done with her questions. I answered them and spoke about my family and upbringing. I was crying, and I just kept saying.
How were you speaking with her?
I was like,
same way you're talking to me?
no, I'm not trying to be loud. That's just the way I talk, Your Honor.
No,
I'm
you were
sorry.
yelling at her.
No, I kept saying, why is it, why is this? But I did think about it all weekend, and I was like, well, if this is an option, you know, I got to deal with it. You know, it's life.
Same thing that you told when they recommended that you go to Everett House back when you first got put on probation. You said, no, I don't need to do that.
No, that's not what I said. I told Jennifer that I thought between the rules of probation and the rules of Everett House that I was going to mess up and end up back here, but instead I caught a new case, and that's where I screwed up, and I'm admitting that. I need this chance.
I'm giving you chances. You can't even follow my simple conditions.
I
said no contact with Michael Agapi.
I know that, Your Honor.
And you, within, I don't know, let's see, you got out of jail when? You got out of jail September sometime? September? And in less than a month, you're with him.
Given this, I know.
You said, screw you, Judge, I don't care what
No,
you
I
say.
did not.
Well, then what'd you say? So why did you just go ahead
I lied
and...
to Jennifer. I lied to Jennifer, and I lied to you, and I lied to everybody. I should have been honest.
You
Jennifer
doing what you want to do when you're told not to is saying, screw you, Judge, I don't care what you say.
I think given anything of probation and anything, a GPS monitor, not to go around him, if anything, I won't. But I told Everett, they said, well, what's going to stop you now? I said, well, first of all, being on camera, that's what stopped me, because I'll be in handcuffs, like quicker than I could think about it.
That was a risk last time. That was a risk in October.
I know.
And you did it. So that's not anything that's preventing you from doing it or deterring you from doing
Your
it.
Honor, I lied, and I should have been truthful with the people that care about me.
No,
most.
I don't care about the
thought it was
lying
him.
part. I care about you having contact with him. You
And
weren't
so do I.
supposed to.
I know.
And you did whatever you wanted to do, just like you did when you met with the NeoCap folks. You didn't want to go to NeoCap, and you had a temper tantrum.
No.
Yes.
I'm sorry.
You're lying to me now if you say
No,
no.
I'm not. I thought I answered all the questions.
You may have. You may have answered them, but you were yelling at him to the point where they rejected you. That they say we're not going to take her because of her attitude and how poorly she behaved.
I kept apologizing to
I don't
the
care if you
woman.
apologized.
I
You
don't
were
mean
still
to-
behaving
I
that
don't-
way.
I don't mean
You're
to
here
yell
apologizing
like
to
that.
me right
I
now.
don't mean to yell.
You're apologizing to me right now because you couldn't follow my rules and you want to do whatever Laura Kovacs wants to do.
No, I don't.
You did. You went and had contact with him. You didn't go to Everett House back in September when they were recommended to you. And now you want to. Because why? Why do you want to go to Everett House now? Because otherwise you're going to prison.
For me. I think it's a good place for me because I'm mentally
Why
ill,
isn't
and
it
I
good?
think
Why
I
wasn't
am
it?
retarded.
Why wasn't it a good place for you when they told
Because
you should go to that a
Because
month
I
ago?
thought I was going to catch a new case and end up back in here, but instead I went with Michael. I wasn't with him at the time.
Why would you
I was
catch a new
living in
case if you
Little
went to
Wick.
Everett House?
Because I told Jennifer between the rules of the rules of probation, the rules at Everett House and all the groups, I thought it was too much for me to handle, and we agreed. Okay, you
So
just
why
did
is it not too
JTP.
much now?
Because
'Cause you
I
have
need
4.5
that in
years
my
of-
life. I
You
need
needed that.
I need too much. I need no time to think.
You needed that then, and it didn't matter.
It matters now.
What matters now because you have 4.5 years of prison
No,
hanging over
I
your
had
head.
a lot of thinking. I sat down in holding in jail for like 6-7 weeks and without medication for most of it. And the bad has outweighed the good with this man. I've done it with alcohol and weed. As long as I know the stipulations I'm going to get in trouble, I think I can handle it.
You haven't. I don't
Given
know why. I don't know why
opportunity.
you think you can. Because you continue getting domestic violence convictions. You have multiple domestic violence convictions. You continued having contact with him when you were told not to, and so that didn't stop you or deter you from
I
doing
know, Your
that.
Honor, but if I could say something, 3 domestics with him, 2 of which he was arrested in as well. I
don't
like
care.
I feel like the victim too. I admit my part very much so, but I feel like
You still committed the offenses.
I know, I admit that. But
You're
I
coming
feel
up
like
with
my
excuses.
sister's. I know, I'm not. I admit my part, but my sister is like, well, you know, it is what it is, Laura. So we don't talk. She had me sitting in jail the last year for something I didn't even do. I can't even talk to make anybody happy. That's how low I feel. I'm sorry, Your Honor. That's all I could say over and over again. I know I lied to everybody, especially the most people in my support system that I have is not even friends or family. I don't have any of that. It's the people like at St. Jude.
I don't care that you lied to people. I care that you did the act to begin with.
I know.
So what I say doesn't matter. What I say is not going to deter you from not doing it because you're going to do what you want to do.
No, I don't.
That's what
I'm
you've
almost
done.
47 years old.
Yeah, when you're almost 47 when I sentenced you last time. We're only here 6 months later.
I know.
So I don't get what's
And I'm
different
trying
now.
to
Why
do
why
it
is
better
everything going to be
myself.
so different now, miraculously different now than it was 6 months ago?
My thinking somewhat has changed, but with the help that I need, like mentally, I think I could do it. I did it with the drugs and the alcohol. I think I could do it with a man. Hopefully.
You haven't shown that.
I know, because I was with Tony for almost 13 years. 12, 13 years, and that's when things were bad.
Okay, so you didn't show it with him. I don't even know what that's about, but obviously you're
That's when he
acknowledging
drank
that
really bad
with
and I
this
left
Tony
him.
guy,
Yeah.
you didn't make any changes. With
I left
Michael
him.
Agapi, you're not making any changes. You have
I don't
prison
need a
hanging
man.
over your head. You have prison hanging over your
I
head,
know.
and you went to go see him anyway. You said,
know.
I don't care, Judge. I'm going to do what I want to do. You're not going to tell me what to do.
I know. I'm sorry.
I don't care if you're sorry. You think saying sorry is just going to excuse
No,
and say,
it's
oh,
not.
she's sorry. It's okay that she can do whatever she wants to do.
Enough.
Sorry?
I can't say more than enough. I am seriously mentally ill. If I could be in Laurelwood or somewhere for the rest of my life, that's what basically I feel like Everett is at one point, and I need something like that. If I could stay there the rest of my life, I would. But it's not permanent, temporarily, and they helped me find my place. And my goal there was to help me to get a place with my emotional support dog that I have. She's a German Shepherd. I'm sorry, Your Honor. I really am.
I don't care if you're sorry.
Okay.
I get it. You've said it multiple times, thinking apologies are just going to excuse you doing whatever you want. Because that's what you've demonstrated throughout your history here with me. You're going to do whatever you want to do, and it doesn't matter what any person of authority has to say. Doesn't matter what I say, doesn't matter what Jennifer says. It doesn't matter. And if someone's going to do something that you don't like, you're going to have a temper tantrum, yell. Is there anything else you want to say?
Nothing further from the defense, Your Honor.
Ms. Himmeline for the state?
Thank you, Your
Both
Honor.
cases, obviously.
Yes, thank you, Your Honor. As the court is aware, the defendant does have a lengthy criminal history with multiple probation violations, including the case that is before the court now. The defendant was given an opportunity in the 23 CR 1368 case to stay away from Michael Agapi, and she chose to violate the terms of community control that was provided to her in that case. She has had prior treatment efforts that were unsuccessful. Given that NeoCap is not an option due to the defendant's behavior, the state does recommend that the court impose a prison sentence in both cases. Thank you.
How much credit is there with both cases? I know it's 75 on the older case.
The new case is 116, Your Honor.
court has reviewed the pre-sentence report investigations, drug and alcohol evaluations. I have considered the facts and circumstances of the offenses involved, the nature of the offenses. 23 CR 1368, I've considered the defendant's performance on probation, the nature of those violations. I've considered what's been said here today by Ms. Kovach herself, Mr. Watson, prosecutor, the recommendations from everyone. All of this is considered in light of the purposes and principles of felony sentencing set forth in 292911. As for the factors in 29, 29, 12, in case 23 CR 1368, I'm going to incorporate all the findings I made at the sentencing hearing in July. With the additional finding today that the defendant has failed to comply with previously imposed sanctions ordered by this court, specifically committing a new offense, having contact with the victim. Those are factors indicating, the defendant failed to comply with the previously imposed sanctions from this court, which is factors indicating not only recidivism is more likely, but it actually happened. Case 24 CR 1277. Nothing factually about the case that stands out, indicating it's more or less serious. As for recidivism factors, the defendant was on probation to this court when she committed the offense. She has a history of criminal convictions. She has violated her probation and bond conditions, so she's failed to comply with previously imposed sanctions ordered by courts. She does not have genuine remorse in regards to the commission of the offense. She just blames the victim. No factors indicate recidivism is less likely. (24 CR 1277) is a felony of the third degree, so there's no presumptions one way or the other regarding probation or community control sanctions. In both cases, prison is certainly consistent with the purposes and principles of sentencing. The question is whether the defendant's amenable to any available community control sanctions, and I'm really having a hard time with that. Because to be amenable to community control sanctions means that you're willing and able to follow the rules, follow conditions that are imposed. And your conduct throughout both of these cases has demonstrated that you're not willing to follow rules, that you're going to do what you want to do. You know, Ms. Kovach, if I were to send you to prison today, it probably wouldn't be, even though I could send you to prison for 4.5 years, it wouldn't be near the maximum. It'd be on the lower end. If I give you this chance and you violate your probation, you're going to be getting near the maximum sentence. You want to take that risk? You trust yourself?
If you get probation and you mess up, the judge is going to give you a lot of time.
Okay.
Well, then talk to the judge.
What I'm saying is that if I were to just send you to prison today, even though I could give you 4.5 years in prison, I wouldn't be giving you 4.5 years in prison. I'd be giving you near the lower end.
Oh.
What I'm saying is that if I give you this chance that you're asking for and you screw it up again,
Oh, no.
you're gonna get
Oh,
you're gonna get that maximum
Oh, yeah.
sentence.
okay.
So my question for you is, are you willing to bet on yourself? Are you willing to take that risk?
Yes. I think I could do it.
Huh?
I think I could handle the rules. That's scary. It's a long time.
Well, you're gonna get one chance and one chance only, and we're not gonna come back here with, if you violate, with there's some new other program or NeoCap. Now I wanna do NeoCap. I've heard about NeoCap. I've had time to think about it because I've been sitting around. I think NeoCap is perfect. It's exactly what I need.
Yeah.
We're not gonna do any of that.
Okay.
You can make whatever pitch you want, but I'm telling you that that's not gonna happen.
Okay. I understand, Your Honor. I appreciate it greatly.
Well, in case 23 CR 1368, on both cases, I'll find defendants amenable. I'm going to extend her community control sanctions by 6 months, so for a total of 2.5 years. In case 24 CR 1277, I'm going to put the defendant on community control sanctions for a period of 2 years. In that case, 1277, I'm going to order the defendant to serve a total of 160 days in jail. She has credit for 116 she's already served. I am going to order that any time after she's served an additional 15 days, she could be released once a bed's available at the Everett House. She's going to serve 15 more days, and then if a bed's available on that day, she can be released on that day. If it's not available for a week later, whenever a bed's available after, what's today, the 10th? After February 25th or after, she can be released. That's just on that case, the 1277 case. Then in both cases, I'm going to order that the defendant enter, successfully complete the program at Everett House. Whatever that program involves and entails, you to follow all of their recommendations. If they recommend something and you say no because you don't like it, you're going to go to jail.
Okay. I understand.
You're not going to get your way because you don't want to do something that they tell you to do.
Sorry.
How long is this program, Mr. Watson?
Well, Your Honor, it's my understanding, it's not a definite time period. I think it's at least 30 days, but my understanding, it usually goes several months. They work, again, with the defendant. There's an IOP program. There's mental health assessments. They work on her with housing. So I don't think there's a definitive period. I think it's when they feel she's ready to move out and they have another place for her to go.
Well, I want her there for at least 60 days.
That's fine, Your
So
Honor.
60 days in the minimum at Everett House. Further conditions, you're not to use any drugs or alcohol. Includes marijuana. I don't care if you have a marijuana card or not. No, none. You submit random urine screens. They have to be negative. 3 AA meetings a week with a sponsor. I want you to continue with psychiatric counseling as well as mental health services. Follow all recommendations from both the psychiatric counseling as well as the mental health services. Take all medications as prescribed. You'd have one doctor, one dentist, and one pharmacist. Sign releases so that probation can talk to those folks. Pay your court costs and supervision fees. You'd have no contact with Michael Agapi.
Yes.
No contact.
Okay.
Text messaging, phone calls, emails, in person. Not to have someone else reach out to him and tell him something or pass a message along. If he has contact with you, you're violating it. So if he has contact with you, you need to hang up on him. If he comes and see you, you need to walk away. Ms. Canals, anything else that you recommend?
No, Your Honor, thank you.
Ms. Kovach, you understand all the conditions of your
Yes.
community control sanctions?
Sorry. Yes, Your
Do you have
Honor.
any questions for me?
No.
Are you
I
sure?
Yes, I appreciate everything.
No,
Thank
I
you.
don't care about that. I want to make sure you understand what you're
Yes.
supposed to do and what you're not supposed to do.
Yes, completely.
If you violate any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense, a motion to terminate your community control sanctions will be filed in both of these cases. And then if after a hearing it's found that you did violate, I could technically extend your probation in each case to a total of 5 years. I can impose more restrictive sanctions, including local jail time, or I can and I will terminate your probation in both cases and send you to prison.
Okay.
And in case, make sure we're accurate, 24 CR 1277, that will be 36 months in prison, 3
Okay.
years.
No.
And in case 23 CR 1368, it will be 18 months in prison. And the two cases will be ordered to be served consecutive to each other for 4.5 years, and they'll be consecutive to any other new charges that you may pick up or sentences that you're serving on anything else.
Okay.
You understand all that?
Yes, sir.
Ms. Simline, is there anything else for the record?
Just bond, Your Honor.
Well, bond's released, whatever bond there was never posted, but bond's released. Thank you. Mr. Watson, anything else?
Just that, Your Honor, should we inform the court when a bed is available, or just when a bed is available, the defendant to be released?
I don't know how that will work. I guess
Okay.
it's through Jennifer. You should let Jennifer know, and then she'll send a memo to the court. I typically just write approved on there, and then the jail accepts that. If you know beforehand, if you learn beforehand when a bed will be available on or after February 25th, you could send it whenever.
Certainly, Your Honor.
And I
And then just,
That'd be the easiest way, but
and just for the record, Your Honor, then Erin Mayer, Mayer, she's the social worker at the public.
how do you spell
defender's
Aaron? I don't know if I
office. Her first name is Erin.
I know, but how do you spell Aaron? E?
Yeah, Errin.
Oh, 2 R's, okay.
Correct, there's 2 R's, and then it's Mayer. She will be picking up the defendant whenever that bed is available from the county jail and driving her directly.
Well, let's put
to
that
her
in the
house.
entry, that she will be released once the bed's available to Aaron Mayer, so then they know that already, we don't have to worry about that. And then I would if you get a date, let probation know, and I mean, if you know a date tomorrow, let the probation know, and they can send me a memo, and I could prove it then, or whenever you find that out.
Thank you, Your Honor.
All right, thank you.
All rise.
we are here this afternoon in the state of Ohio versus James Wheeler. First on case number 22 CR 973. The defendant is represented in that case by attorney Christina Bruack. He did plead guilty to one count of possession of heroin, a felony of the 5th degree with the attached forfeiture specification in that case. We are also here for 22 CR 1174, in which he is represented by attorney John Fatika. He did plead guilty to one count of receiving stolen property and one count of identity fraud, both felonies of the 5th degree. He was referred for a pre-sentence report, which has been completed. We are here today for the purposes of sentencing. On case ending in 973, he has 6 days of jail time credit. And case ending in 1174, he has 8 days. Thank
Say
you.
that one more time, please.
6 days in case 973 and 8 days in case 1174.
Thank you. Mr. Fatika, I'll start with you. Any reason not to go forward with sentencing? You're here representing him on 1174, 22 CR 1174.
No reason not to go forward, Your Honor. I've had an I've had an opportunity to review the PSR and the drug and alcohol evaluation. I'd like to highlight the fact that Mr. Wheeler is 63 years old. We acknowledge that he has criminal history, but his last criminal conviction was back in 2016. He's been a concrete finisher for years. He does have a support system demonstrated by the letter submitted on his behalf. He's been going through counseling through Strive, living with his sister. He has a sponsor. Also like to address the severe trauma that Mr. Wheeler withstood as a child. I don't know that he's fully recovered from that at this point, but we'd ask the court consider community control sanctions. And I'd ask for permission to have his sponsor and sibling speak, and then have Ms. Brooks speak.
Sure, well, we can hear from them now then. Whoever it is that would like to speak on behalf of Mr. Wheeler, you can just stand right where it is that you're seated. Spell your last name so it's clear who's speaking, then you say whatever you want me to know.
Good morning, Your Honor.
Good morning.
My name is Mike McCarthy, MCCARTHY. I've been Jimmy's sponsor for the last little north of 2.5 years. I've known him for over 30. We do the same type of work. I was in that situation myself. I sponsor him. He's been taking the suggestions. He's got a good support group. He's got a lot of friends in AA.
Can you speak up a little bit, please?
He's living at his sister's house now, which is a good environment. But, from what I see, he's working a program that he's supposed to be working. I haven't seen anything different. He follows suggestions. And he's been keeping his head above water the last 2.5 years. We run around in meetings together and talk. I was in the same situation here. I haven't been in this court in a long time myself, but I've been. I did all that stuff. We get older, we start to listen, hopefully. Things start sinking in, and I think things are starting to sink in for him. It's a long journey. One foot in front of the other, he'll be all right. That's pretty much all I got.
Okay, thank you, sir.
Thank you.
Is there anyone else?
My name's Randy Wheeler, W-H-E-E-L-E-R. I'm James's brother, younger brother. For the last 2 years, forgive me, I've watched him transform into the man that he is. And I have taken him, I've witnessed him work the program. He's a hard worker. He's a great brother. And I just want what's best for him. And I know if the court gives him an opportunity to move forward, that he is going to excel and just keep getting stronger and more healthy. And that's all I can say.
Thank you.
Kelly Cover, C-O-V-E-R. I'm James's sister. What can I say? Jim's, had all his life he did drugs. All his life. We come from a messed up family. A very messed up childhood. I've got 5 brothers, 1 sister, and from parents, grandparents down, everybody's an addict in my family. I currently have 13 years sobriety, and you gotta want it. And 2.5 years ago, Jimmy was living with my other brother, Kevin, and Kevin had passed away. And that's when Jimmy came and lived with me. And I watched that man, he was on my couch for 20-some days, withdrawing real bad. And he never looked back. And I watched him, I finally got to know my brother without the use of, for the first time, and it's been me and him for the last 2.5 years. I couldn't have done it without him. And because of my sobriety, I couldn't allow him in my house prior to him being sober. That was just the way it had to be for me. And I just, I got him into Strive with me. I've been in Strive for a long time. It works for me, and it's working for him. So I don't know. I just see him doing the right things. Otherwise, he wouldn't be living with me no more. But I just hope you guys, with probation. I mean, it's just a matter of visiting probation. If you're doing the right thing, you should fly through that. So, I just hope you give them that opportunity. Thank you.
Thank you. Well, Ms. Brooke, in regards to case 22 CR 973, is there any reason we shouldn't go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client in regards to this case?
Yes, Your Honor, thank you. May it please the court to borrow briefly from Mr. Fatika's statement, as has been, the court has advised Mr. Wheeler, 63 years old. He does not deny 64. He does not deny that he has had a troubled history, starting with a troubled childhood into a troubled adulthood and a history of substance use and abuse. He has advised that in November of 2021, his brother had passed away, and at that point, he made the conscious decision that he needed to work towards getting sober, to put himself in a position where that was not going to happen to him. He stated to me that he began with Strive about 3 years ago with a dual diagnosis. He did advise that there was a diagnosis of PTSD and bipolar, and that he is participating in the MAT program with Suboxone treatment, that he attends once per month counseling sessions with Dr. Jeffrey Terrell at Strive, and the same doctor is also in charge of his medication management. And in the letter provided that was filed by Mr. Fatika in case number 22 CR 1174. I did not file the same under the case number 22 CR 973 to avoid redundancy. But the letter from Strive that was submitted did advise of the current medications that he is receiving and under the regimen of care with Dr. Jeffrey Terrell. He further advises that he is in attendance of NA meetings. He attends approximately 3 to 4 per week, and is presently keeping a log of those meetings. He did advise me of his sponsor, who is here with him today, Mr. McCarthy, and who kindly gave a statement on his behalf. He did want the court to be aware of the fact that he does have strong family support and care in the form of his brother Randall and his sister Kelly, who were present with him in court for his change of plea hearing last month, and are also here with him today as a sign of their support and care for their brother. Your Honor, I also, in my statement to the court, I cannot minimize, deflect, or avoid the judgment entry that was ordered by this court on January the 29th. And I believe that is something also that Mr. Wheeler would like to address to the court as well, because again, it is quite significant given the positive tests that came about from probation. Your Honor, the most important thing that Mr. Wheeler wants the court to be aware of, and he did actually prepare a written letter that he would respectfully ask if the court would allow him to read aloud to Your Honor, is that he does want the court to be aware of the fact that he owns his wrongs, he owns his wrongdoings, he owns his mistakes. He is proud of the fact of the work that he has accomplished through his counseling program, the fact that he has obtained and maintained gainful, steady employment, working with concrete finishing. So he is making inroads into taking a life that was very disturbing and trying to turn it into something positive. We would respectfully request if the court would be so inclined as to consider a period of community control if the court were inclined as to veer from that. We would respectfully request if the court would consider jail treatment program for Mr. Wheeler.
Wasn't that still community control? That's still community control.
Oh, yes, Your Honor, I apologize, I misspoke, but if the court would incorporate that into a term of community control with jail treatment.
Okay.
Thank you, Judge.
Thank you. Well, Mr. Wheeler, the law allows you to address the court before sentencing. You can say anything that you would like. You're being sentenced on both of these cases, so you have an opportunity to speak as to both cases. Is there anything you want to say at this time?
Your Honor, first I would like to apologize for taking your time this afternoon. I also accept responsibility for my actions. I would like to explain how my life went from hell to finally realizing where I had gone wrong after over 50 years. I felt that I had to keep myself medicated to cover the pain and suffering from the child abuse and neglect as a small child. A child that was locked in the basement until he was 9 years old. A child that didn't attend school until 4th grade. A child that had no clothes or bedding and just a bare, empty room. A child that was barely fed and would eat out of the neighbor's garbage can at night. A child that had no toilet facilities that would really be cleaned up. A child that would be beaten so severely by his drunken father, the one that was supposed to love him and not beat him, with pool sticks and razor straps and so on. A child that didn't even know how old he was or what holidays were, and didn't know he even had a baby sister until she was 2 years old. A child that was finally rescued from there, and the state placed me in a foster home where the parents introduced me to cocaine, marijuana, and alcohol. I finally found something that took all that pain and suffering from me. That self-medicating would take me in and out of jail to prison for the next 50 years, until 2.5 years ago, my brother that suffered the same life as I did as a child, lay dying in my arms after smoking his last hit. I wanted so badly to go with him, but by the grace of God, my sister wasn't having that. She took me in and got me well, and introduced me to Dr. Terrell at Strive, where I found a better way to live, to finally realize those things as a child weren't my fault. I don't have to self-medicate no more. This has been the best 2.5 years I've ever had. Your Honor, I ask you, don't set me backwards. Let me keep moving forward. As far as this positive test, the Suboxone is an opiate, and Adderall is an amphetamine. I've worked so hard for 2.5 years. I don't know how it came out positive.
Who did?
I don't know how.
Well, because you used.
I did not use, though. I did not use. I swear to God, my dead son's grave. I did not use. I've been too hard for this. I really have, Your Honor. I'm not trying to...
You walked into probation the second time before you gave that test, and before you gave the test, you tell them, you know, these drugs I take could test positive for cocaine. Just out of the blue, you decide to say that.
Because previously, they tested it to Terrell's because I had taken too many, the Adderall to come up with an amphetamine.
Well, and that
I know
always
it's
comes up with
early.
an amphetamine, and we know
I
that,
don't
and we
know.
don't violate.
I don't
Hang
know.
on, I'm talking. When it comes up, when people take Adderall, we know that tests positive for amphetamine. Yours did the first time you were here. You weren't violated. Your bond was not revoked because that's attributed to the Adderall. And then when you walked in the second time, you tell them ahead of time that, just so you know, these drugs I take sometimes test positive for cocaine. That's absurd. And you told them that beforehand. So you knew exactly beforehand what was going to happen.
I did not use that, Your Honor. I did not use.
Anything else you want to say?
No, thank you.
Mr. Vatika, Ms. Bruick, anything else?
No, thank you, Your Honor.
Nothing further, Your Honor. Thank you.
For the State of Ohio, Ms. Cantor?
Thank you, Your Honor. The state's meetings did waffle between recommendations between some type of intensive treatment and prison, Your Honor. The defendant does have 2 prior prison terms, though it is accurate that he has not had any convictions since 2016. However, I was aware of his positive test and his bond being revoked, and at this time, that positive test minimizes all the work that he says he has done for the last 2 years, and we cannot comport that it is both true that he has been sober this entire time, for which he was out on a warrant for several years, and that he also tested positive for what he did, which was tested on the 29th, so at this time, the state is in a position to recommend prison.
This court has reviewed the pre-sentence report investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the underlying offenses, the nature of those offenses. I've considered what's been said here in court by Mr. Vatika, Ms. Bruick, the defendant himself, family members, sponsor that spoke. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, factors indicating the conduct is more or less serious. Nothing really stands out to the court in either of these cases indicating it's more or less serious. As for recidivism factors, many of these are present. Defendant has a lengthy history of criminal convictions. He has not responded favorably in the past to previously imposed sanctions. There appears to be a drug problem. Now, the defendant's going to deny that he's got any drug issues. Not that he's got a drug problem from a lifetime drug problem, but obviously here we have a positive screen here that where he tested positive for cocaine and fentanyl. And when he came in and brought this, before he gave this test, he basically told him he was going to test positive for cocaine. He walks in and makes a statement that, these medications I'm on often, erroneously test positive for cocaine. Just out of the blue. You don't do that. You don't do that beforehand. You didn't do that beforehand when you gave the first test, after you left here and you were referred over there. You didn't go over there and say at that point, these medications I'm on could be positive for cocaine. But you did that when you showed up, and sure enough, it was positive for cocaine. And you relapsed. And you're afraid to admit it to these folks. That's what this is all about. The court also notes that the defendant was gone for 2 years. In this case, when he was first arrested, got arrested, failed to appear to court. There was a warrant out for him for 2 years before he was finally arrested. That's a factor indicating recidivism is more likely. Nothing indicates it's less likely. Under 2913B, well, I will note also under the recidivism factors, the defendant does not accept responsibility in regards to the case with the credit card. He denies he committed the offense, quite frankly. He says he was, not that he denies that he used this credit card, but he denies having any knowledge that this card was stolen and there was anything wrong with this card. He repeatedly mentions that he was just given this card, told to go get something, he was promised some heroin if he went and bought it, which should have been a red flag. But he never even looked at the card, never looked at the name, didn't notice the name on it. Well, then if that's the case, then you didn't do anything wrong. You have to have knowledge that the card was stolen and it was being used improperly, and you denied that, quite frankly. Now, in case 973, he accepts full responsibility. That's the drug case, not the credit card case. Under 2913B1, the court finds the defendant has previously served a prison term. That overrides any presumption for probation, permits the court to impose a prison sentence without having to make any special findings for that. Mr. Wheeler, when I look at the whole big picture here, I recognize that you had a tough upbringing. I don't dispute that. And that your whole life has been using drugs. And I'm not going to dispute, I guess, that for the last 2 years, maybe you have made some effort. It appears that you are. The folks here are speaking highly on your behalf, and they're not going to come in here and just flat out lie about it. I don't believe that for 1 second. But you still have a problem, and you relapsed, and you're afraid to say something about it. But the court recognizes that you have made some effort over the last few years. Again, I'm not going to be blind to that. But you need some help. I'm just going to let you walk out of here. When you used. I wouldn't let you walk out of here anyway. You deserve to be punished. You were gone for 2 years. You committed these offenses. You deserve to be punished, and there deserves to be consequences. But I'll give you a chance on community control sanctions, even though I understand the prosecutor's recommendation for prison with your history. And if you're going to maintain your position, then this treatment won't work, and you'll be back here before you know it.
No, I won't, sir.
But on each case, I'm going to place you on community control sanctions for a period of 2 years. In each case, I'm going to order that he serve 60 days in jail. That's a concurrent jail sentence. He's got 8 days of credit on 1174 and 6 days in 973. I want him to enter and successfully complete the jail treatment program, follow all the recommendations. Upon completion of that program, he is to complete either the treatment program at Lake House or Concord Pines. Follow all their recommendations. Further conditions, you're not to use any drugs or alcohol. You must submit random urine screens. They have to be negative. A positive screen will result in a violation being filed. You're to attend at least 3 AA meetings a week and have a sponsor to obtain and maintain full-time employment. You'd have one doctor and one dentist that could prescribe you medications. If you have a specialist, that's fine too, but only those doctors that probation is aware of can give you prescriptions. You need to sign releases so they can talk to those folks if necessary. You're to take all medications as prescribed, obtain a mental health evaluation, and follow whatever recommendations they make for any type of counseling to deal with what you've explained to this court. Pay your court costs and supervision fees. I'll order the forfeiture of the contraband and instrumentalities in 22 CR 973 and dismiss count 2 of that indictment. I will release bond on both cases, even though there's a warrant out for the defendant now. How will they execute the warrant, or do they want the warrant vacated since he's been ordered to go to jail, or?
I'm not 100% sure.
Right. Yeah, why don't you put in there to vacate the warrant for the case that it was issued on, since he's, I don't know if we only issued it on one case, Jennifer?
Yes, Your Honor. On the 973, it's revoked.
All right, so vacate that warrant, 973.
Yes, sir.
So, Ms. Culotta, anything else I should be thinking about here?
No, thank you, Your Honor.
Mr. Wheeler, you understand all the conditions of your probation?
Yes.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, in case 22 CR 1174, it would be 12 months in prison on count 1 and 2 to be served consecutive to each other for a total of 24 months. And in case 22 CR 973, it'll be a period of 12 months. That sentence will be served consecutive to the prison term in 1174 for an overall total with both cases of 3 years in prison. And that would be consecutive to any other sentence that you may be serving at that time if something new were to occur. Ms. Contour, is there anything else for the record at this time?
Nothing more.
Mr. Fatika?
No, thank you, Your Honor.
Ms. Pruitt?
Nothing further, Your Honor. Thank you.
All right.
in the matter of the State of Ohio versus Dante Wilson, case number 24-CR-1002. Defendant is present in open court today with his attorney, Mr. Chad Mulkey. At the last proceeding held January 7th of this year, the defendant pled guilty to one count, that being possession of cocaine, a felony of the 5th degree under 2925.11a, and carrying a forfeiture specification. Your Honor accepted the plea and ordered a PSR as well as a drug and alcohol evaluation. We have read the report. We are ready for sentencing. It should be noted that the defendant has 40 days of jail time served, and that there is no prior agreement as to sentencing, Your Honor.
Thank you. Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. And then when I'm done, I believe his mother is here and present and would like to address the court when appropriate if possible.
Sure.
Thank you so much, Your Honor. Your Honor, on behalf of my client and after reviewing the pre-sentence report, I would note he is 38 years old. He is single. He does have a 15-year-old child. He is gainfully employed at Wilson Construction. He is a high school graduate and has a valid driver's license. He is certainly no stranger to the courts and the judicial system, Your Honor. He has been to prison and to NeoCap. He has completed a jail treatment program, Your Honor. He is asking this court for an opportunity for community control with outpatient treatment, Your Honor. This charge is a felony of the 5th degree. The presumption in favor of prison is overcome. However, he believes he can demonstrate adequately an ability to this court to follow his orders on probation, Your Honor. So taking that into consideration, I know he has some prior history. He seems to indicate that his major issue is with alcohol, but he did acknowledge to me an issue with drugs as well. So he is asking the court for help. He would like to avoid prison if at all possible. Certainly discuss that as a possibility for him, but with everything that he has desired to want to accomplish, Your Honor, he doesn't believe that prison would be the best option for him in this matter, Your Honor. So that is what I have to say. I told him he'd have the opportunity to address the court, and then, as I said, his mother would also like to address the court. Thank you.
Well, we could hear from whoever would like to speak on his behalf at this time. We can do that first. So whoever it is, you state your full name, please spell your last name so it's clear who's speaking. Then you can go ahead and say whatever you would like me to know.
Yes, sir. My name is Darlene Wilson Hall, Hall, and I'm Dantes Wilson's mother. And Your Honor, I just want to say I done had 2 strokes, brain aneurysm, and now I have a blood clot. And he has been an excellent father and an excellent son. He has his problems with the alcohol and everything. So please, I'm just begging the court to get him some kind of mental health and help with the substance abuse. And that's all I got to say.
Thank you. Mr. Wilson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, I do, Your Honor. I would like to say that I'm not asking for any sympathy, Your Honor. I'm not asking to be let out of jail today, Your Honor. I'm not fully asking to be on probation today, Your Honor. I am asking the courts today, Your Honor, is can I please get some type of rehab, for my alcoholic addiction and for my addiction as far as drugs. I have been in front of you before, Your Honor. I have been, I completed your programs, but the only thing, Your Honor, I haven't completed with you is rehab, Your Honor. I need an opportunity to prove to you and prove to the courts that I can complete rehab successfully as well, Your Honor. I just ask for a chance. I'm not a threat to society. I'm not a threat to my community, and I'm a nonviolent person, Your Honor. I am harmful. I'm not harmful, Your Honor, at all, and I don't see why I shouldn't be, given treatment. I see, understand, Your Honor. I want to apologize to the courts, and apologize to you, Your Honor, and apologize to a probation officer as well for the excuse that I made for altering my urine, Your Honor. And I know it was a bad decision that I made, and it was very terrible, and I know I wouldn't do that again because it didn't work for me, and I see it gets me nowhere, Your Honor. I just asked.
That's the only reason you wouldn't do it again?
Yes, I wouldn't do
Because
it
it
again.
didn't work?
No, it didn't work at all.
I'm saying that's the reason you wouldn't do it again, is because it didn't work?
No,
Not
I
because
wouldn't do
it's-
it. I wouldn't.
Not because maybe it's wrong?
No,
That
I'm
you
not.
should-
I wouldn't
That
do
you
it.
should follow the court's orders?
Yes, I should follow the court's order, Your Honor, and it is wrong and it's unhonorable for me to do a such thing like that, Your Honor, and it's not right, and I'll take 100% accountability for that. And I'm not, again, making any excuses for anything, Your Honor. And also, I believe prison term is, I would not benefit from going to prison, Your Honor, because I can get drugs there, I can get alcohol there, and that's not what I want for myself, Your Honor. I want to shape up and get myself together, Your Honor.
Well,
For
you
my
shouldn't
daughter.
demonstrate that, because when you left here last time, you were just instructed to go to the probation department so we can start the whole process going in regards to seeing whether you were appropriate, and you didn't go.
And I made an honest mistake for doing that, and it was a dumb decision.
Why is it an honest mistake? How is that an honest mistake?
Because I'm learning from it, Your Honor, and I understand the seriousness of what took place that day and what I'm being brought forth to you again.
Anything else you want to say?
I just ask that you please, Your Honor, give me an opportunity, to get myself together, to get my life together, Your Honor, and some type of rehab, some type of treatment, so I can be there for my family, be there for my daughter in these times. She's 15, Your Honor, and in these times she needs me, Your Honor, and I need to be out there taking care of her and making sure that I'm doing right and making sure that she's doing right as well, Your Honor.
Mr. Mulkey, anything else for the state, for the defense?
Nothing, Your Honor. Thank you.
For the state of Ohio, Mr. Devanche?
Yes, thank you, Your Honor. Defendant does appear to have a problem, particularly with alcohol, but it does not appear that the defendant has shown he's a proper candidate for probation. He does have an extensive and varied criminal record dating back some 20 years, at least 3 felonies, convictions, one of them being a serious felony 2, attempted aggravated robbery, which was actually bumped down from an F1 as indicted. Defendant has committed several PVs. One time when he committed a PV, he was then sent to prison. In fact, he's been in prison twice. In addition to the felonies, he has a wide variety of misdemeanors in his past, and consistently over time, including things like criminal trespass, disorderly conduct, open container, resisting arrest. In this case, Your Honor, at the time of booking, force had to be applied to the defendant because he was argumentative and uncooperative. And all of these charges or convictions have been over the course of time and in various jurisdictions. And in fact, now he has 2 open warrants. Treatment doesn't seem to have worked. I mean, he's completed NeoCap as recently as 2022, completed it, but it doesn't seem to have stuck. He also, as Your Honor noted, didn't go straight to probation and instead came there 3 hours or so late on the day of his plea and apparently delivered a sample of adulterated urine. For these reasons, Your Honor, we do not believe that probation is in order. As far as prison time, we would leave that to the discretion of the court if it sees fit. Thank you.
This court reviewed the pre-sentence report investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything said here today. Received a few letters in support of the defendant. I've read and considered all of those. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, factors indicating the conduct is more or less serious. Nothing stands out factually about this case indicating it's any more or less serious.
than what normally constitutes the commission of this offense. As for the recidivism factors, however, many of these are present. Defendant has a lengthy history of criminal convictions. Convictions go back 20 years. He has served multiple prison terms before in the past, the most recent being from this court after he violated his probation on 3 separate occasions. So he has failed to comply with previously imposed sanctions ordered by courts as well. And he's not just my case, but the prior cases, he's also been on probation and violated his probation. But for my case, I mean, he was given rehab, multiple chances at rehab. Given the jail treatment program, went to more counseling, went to NeoCap. Just completed NeoCap just less than 3 years ago, 2.5 years ago. He just continues doing the same thing. He refers to these as mistakes. A mistake is not something that you continue to do over and over and over.
Yes, Your Honor.
These aren't mistakes.
And I bump my head, Your Honor, and you know I have hope, and I haven't lost faith that I still can get myself together, Your Honor.
Well, then you'll get a chance to. You should do that. You haven't done it. You haven't done it. You don't have to commit crimes to get help. You don't have to be court ordered to go get help.
I know, Your Honor, but I push it off, and I'm also in denial of that sometimes, Your Honor. And that's why I come forth to you, Your Honor, to ask, because you give me the opportunity and give me a chance to do things right, Your Honor. And
All right, you've already had a chance to speak, Mr. Wilson.
Yes,
Now, it's my turn now.
Yes, sir.
But I gave you that chance before in the past, and you've continued to engage in the same behavior, and then you play games with this court. You show up here, you don't go to the probation department, you have one story after another. You had a doctor's appointment at the emergency room. That makes zero sense. And then when you're called on that, you said, well, you were going there, but then you didn't want to wait, so then you left. And you come back here with adulterated urine, screwing around the court. And that's, being on bond is sort of, with conditions that follows an audition for this court to see how you're going to do while you're on probation. And you failed your audition miserably. But those are all factors indicating recidivism is more likely. There's nothing indicating it's less likely. He'll say and do what he needs to do to try to get away with something. Under 2913B1, defendant has previously served a prison term. Prison is consistent with the purposes and principles of sentencing. There's no way the court could look at this and the defendant's conduct in this case while on bond. In the past, he was on probation in this court not that long ago. He had 3 separate violations. I gave him break after break after break. I can't find he's amenable to community control sanctions. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 9 months. He'll be given credit for 40 days he's already served. You need to advise you upon your release. You could be placed on post-release control for up to 2 years if you are and you're violating any of those conditions. The parole authority can send you back to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I'll order the forfeiture of the contraband and instrumentalities in the specification. I will order the release of defendant's bond, forfeiting that. And defendant's ordered to pay all costs. If you want to get help, you can get help. You can start when you're in prison, you can get help when you get out. If you're really serious about it, that's what you will do. I guess time will tell there. Is there anything else for the record, Mr. Devanche?
Just to clarify, Your Honor, I was not sure I heard, you said no shock probation, is that right?
No transfer to transitional control.
Thank you.
Mr. Mulkey, anything else?
Nothing else, Your Honor.
Thank you.
We're here today in the state of Ohio versus Philip Terry, case number 24CR856. The defendant is present with counsel Bill Watson. We're set today for a sentencing hearing. We were last before you on January 9th, 2025, and at that time the defendant pled guilty to count 1, possession of cocaine, a felony of the 5th degree with a forfeiture specification. During that hearing, a pre-sentence report and drug and alcohol evaluation were ordered. Those reports have since been completed. The defendant has 17 days of jail time credit, and the state would move to dismiss the remaining counts of the indictment. Thank you.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be extremely brief. Mr. Terry is a young man who has some problems. He likes to have his fun, and he likes to party with young ladies. And this evening, or for this incident, on the evening of this incident, he was in a car in downtown Willoughby when the Willoughby police came upon him engaged in, I believe, intercourse with this woman, and upon a search of the vehicle, they found cocaine. My client has taken full responsibility for that, told the officers it was his, told the court that it's his. As I mentioned in chambers, Your Honor, normally when I come to sentencing on drug cases, I like to have a plan, if you will, with a treatment facility lined up. I did not take those steps in this case, even though this is a drug case. I don't believe Mr. Terry is a hardcore drug user. I had started this speech by saying he likes to party, and I think this was part of the fun that evening. That doesn't take away from his responsibility of not having it. You're going to hear in a moment from Mr. Terry, but he's the father of a young child. He does live with his live-in girlfriend. He does work part-time, but he also cares for his child for the rest of the time, so he is keeping busy. I know, Your Honor, he's got somewhat of a record, but due to the fact this is a nonviolent offense and that he stepped forward, he took responsibility for his actions, I'm hoping the court will consider a community control sanction with whatever restrictions the court wants to put into place. He is currently, or he is working with Signature Health, was in an intensive out treatment program. I don't know if he's fully completed that or not, but Your Honor, if the court feels it necessary for him to jump back in there, I've just spoke with Mr. Terry. He's told me he'll tackle it head on. He wants to do whatever this court is willing to ask him to do. Again, you'll hear from him in just a minute, but he's ashamed of his actions, and I don't think you're going to see him in this capacity again, Your Honor. Thank you.
Thank you. Mr. Terry, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
Go ahead.
I would like to apologize to the Lake County Court and the city of Willoughby for breaking the law. I would like to take full accountability for my actions. I'm not a bad person, Your Honor, and I don't think I have a drug problem, but I am a recovering addict. I recently completed an IOP program at Signature Health, and I'm currently in that aftercare program. I've been working with my caseworker to help me get enrolled in Ohio Technical College to get in their mechanics program. And if you give me a chance to go home, I promise that I will never give you a reason to summon me to your courtroom again. I have a family that needs me, and my son's first birthday is Saturday, and it would mean the world to me if I could be there to celebrate with him. And I would also like to say that I didn't mean any disrespect to the court for the dirty urine and getting my bond revoked. I was under the impression that my medical marijuana card would be acceptable.
Not when you actually went to the probation the first time.
No.
You were told then it wouldn't be.
Right.
Anything else you'd like to say?
That's it.
Okay. All right, thank you. Mr. Watson, anything else you want this court to consider?
Nothing at this time, Your Honor.
And Ms. Bell for the state.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and there certainly are some things that are troubling. The defendant committed this offense while he was on probation. He has a prior prison number, few PVs in his history, a history of criminal convictions. However, despite all that, the state does not believe that he's an appropriate candidate and this is an appropriate case for prisons. The state would recommend community control to include continuing treatment. Thank you.
Thank you. Mr. Terry, when you go to Signature Health, where do you go physically? Like, where is it?
It's in Willoughby.
Is it the new building?
Yes, it's on Manor
Like, you can
Ave.
walk there, right?
Yes.
Yeah. Okay. This court has reviewed the pre-sentence report and investigation. Drug and alcohol evaluation. I've considered the facts and circumstances of this offense, the nature of this offense. I've considered what's been said here today in court by the parties and defendant. All this is considered in light of the purposes and principles of felony sentencing, which are set forth in 29, 2911. As for the factors in 29, 2912, nothing stands out factually indicating it's more or less serious. As for the recidivism factors, the court notes that the court finds the defendant was on probation at the time he committed this offense. He was on probation in Ottawa County, but however, that probation is being supervised by Lake County. He has a prior criminal history that goes back, that's my math, 18 years. He has failed to comply with previously imposed sanctions ordered by the court. There are multiple probation violations here. In fact, even on the probation that he's being supervised for with Ottawa County, he's been violated at least twice. Not counting any potential violation for committing this new offense while on probation. He was previously served a prison term. He was given PRC, which was revoked, and he was sent back to prison. That rarely happens, but it happened with Mr. Terry. Violated his bond by using marijuana while he was on bond. Court notes he does have a medical marijuana card, which was apparently he was permitted to use that by with his Ottawa County Probation Department. Not had permission to do it here. He tested positive both times he appeared at the probation department. The second time was actually a higher sample. There's no factors indicating recidivism is less likely. Under 29-29-13A1, defendant previously served a prison term, which overrides any presumptions for probation. With the defendant's history and being on probation and having violated multiple times, prison easily is consistent with the purposes and principles of sentencing. But I'm going to give you one chance here, Mr. Terry, to continue on probation with the Ottawa County. Though this is going to be different, I can assure you of that. Even though you're still going to have the same people supervising you, when they supervise you for another county, they basically have to play by their rules. And they're just enforcing their rules. Our rules are going to be different. Our rules are, first of all, going to be enforced. You're not going to get multiple violations. You have to follow the rules. And if you don't, you're going to get violated and go to prison. It's as simple as that. I'm going to put you on community control sanctions for a period of 2 years. In order that you serve 30 days in the Lake County Jail, you have credit for 17 days you've already served. I'm going to order that you complete the outpatient treatment program that you started, I think maybe you already have, and you participate and complete the aftercare program. And when I say participate in the aftercare program, that means you have to show up. It's not going to be like it's been that you've been doing. When you're there, apparently you do well, it seems like. But you're not there all the time. You miss appointments all the time. If you find out that you're not going on a not going all the time, not on a consistent basis, that you're not going when you're supposed to be there, you'll be violated. You understand that? You live less than a mile away from that place. There's no reason that you should be missing the amount of appointments that you miss. So we're not going to put up with that anymore. You've been getting away with that, with this aftercare, going when you want to, not going. It's been very sporadic. That's not going to happen anymore. If you miss appointments, you're going to get violated. You understand that?
Yes, Your Honor.
All right. You're not to use any drugs or alcohol. That includes marijuana. So you're not permitted to use marijuana, and you're not permitted to use it pursuant to the card that you have. If to submit random urine screens, they have to be negative. Positive screen is a violation. I want you to attend 2 AA meetings a week. You have a sponsor. You're to obtain and maintain either full-time employment or schooling. I think you said you want to go to school to become a mechanic. You can do that as well. But on a full-time basis, you're either working, going to school, or some combination of the two part-time to keep yourself busy. Continue with mental health services through Signature Health. Take all medications as prescribed. I want you to, probably missed it, so I want you to get the psychiatric assessment. I was scheduled for the 23rd, so you probably missed that, I'm assuming, right? You didn't get to do that. You're supposed to have a psychiatric assessment with Signature Health on January 23rd. That's probably right about the day you were arrested here, or maybe you did have it.
I went to the.
Yeah, that was probably the day before you got arrested.
I got arrested on the 27th.
Okay. So you had that assessment?
Yes.
Okay. We'll follow all recommendations then from the psychiatric assessment, again, including taking all medications as prescribed. Pay court costs and supervision fees. I'm going to order the forfeiture of any contraband and instrumentalities in the specification. Count 2 will be dismissed. Ms. Newman, anything else that I'm missing here I should be thinking about?
Nothing else, Your Honor. Thank you.
So, Mr. Terry, understand all the conditions of your continued probation?
Yes.
Well, not continued, I guess it's continued. This is a separate probation. And that's important to make sure you know that. This is separate and apart from Ottawa County. They may not do something to you if a violation doesn't mean we have to follow that. You understand that?
Yes, Your Honor.
All right, you understand all the conditions then?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit a new offense while on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years, I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months in prison. So that's what's hanging over your head. You understand that?
Yes, Your Honor.
All right, Ms. Bell, anything else for the record?
Nothing further, Your Honor. Thank you.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
before you today on State versus Archie D'Angelo Archie, file 24 CR 966. We're here today for sentencing. As there was no pre-sentence report completed, the state of Ohio is just prepared to go forward. Thank you.
Thank you. Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor. We're prepared to move forward with sentencing.
Anything you want to say on behalf of your client?
I would like to say some things on behalf of Mr. Archie, Your Honor. As you know, he wrote you a letter which explained his circumstances a bit as far as what was going on leading up to the dates of the incident. We had a trial in this matter, so you're familiar with the facts. But I think most importantly, there were other individuals that were charged with similar or the same crimes related to this same incident, and one of those individuals I know was already sentenced by this court, and my understanding is that for the charges that were related to conveyance of drugs into the jail, that individual received a 4-year sentence, but that there were 2 different methods of conveyance that individual was involved in. One was through the window, which were the same allegations as Mr. Archie, and one was with flash drive. So with that said, Your Honor, we'd be seeking a prison term of 2 years. I think it would be similar to what the other individual was sentenced to, again being that individual received 4, but there were the 2 different methods of conveyance. I do assert or point out that I believe the felonies of the 5th degree, the trafficking and the possession, would merge with each other in that they're very similar to the elements of the conveyance. So I would argue that.
Well, let me interrupt you. I am going to merge the trafficking and possession charge.
Thank you, Your Honor. And I would offer that although those 2 charges may not merge into the conveyance, that they're similar enough in element, conduct, and those sorts of things that a concurrent sentence would be appropriate. So we're asking for 2 years, Your Honor, and although the court may not make the finding that Mr. Archie showed remorse, I think that by seeking a prison sentence by and through myself, knowing that he's not going to get probation, and dealing with it that way to some extent shows remorse. He's not up here asking for community control or anything of that nature. So we would ask for a 2-year prison sentence with credit for 104 days, Your Honor. Thank you.
Thank you. Mr. Archie, you have the right to address this court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
No, I think my attorney covered it. No.
Thank you.
Your Honor, I did realize I believe Mr. Archie's mother may like to say some words if the court would so allow.
If whoever would like to speak on his behalf may do so.
And I did speak with her this morning, so I do have an idea of what she's going to say, and I have no issue with her speaking.
Ma'am, if you just state your full name and spell your last name for the court reporter, then you can take your time and say whatever you'd like me to know.
Yes, Your Honor. My name is Elizabeth Archie, and my last name is Archie. I'm a little nervous.
That's okay. Take your time.
I just wanted to give you a little background in regards to my son. We're very much aware that, the case has already been taken care of and things. I just wanted to share that there has been a lot of grievance and loss in his life. I feel somewhat responsible. Sometimes that when we grieve, we don't always make the right decisions, and I know his choices haven't been the best. And I was just asking for lenience in regards to sentencing. And we respect the other part of everything.
Thank you.
And he has support from his family. Thank you so much.
Thank you. Mr. Hinton, anything else on behalf of the defense?
Your Honor, I would just reiterate that because Mr. Archie has folks here that care about him, I certainly think there are some good traits inside of him, and he does have support here to assist him. Thank you.
I'd like to say something.
You want Mr. Hinton?
May I have a quick moment?
Yes, please. Hang on a second.
Thank you, Your Honor. I have no issue with this witness speaking at the sentencing.
All right, sir, state your full name, please, and go ahead and say whatever you'd like us to know.
Demetrius Williams, Mr. Archie's cousin.
Can you spell your last name, please?
Williams. I always looked up to Mr. Archie as my cousin, as a big cousin. He's a couple years older than me. We were always raised together, tight-knit family. I'm not making excuses for anyone because I believe my cousin accepts full responsibility for his actions, and I just ask for grace and mercy from this court. From a person who, I just came home from serving 14.5 years in prison. So I kind of understand the decision-making, what my auntie said, when you grieve and you lose people, you don't respond the right way. So I understand his decision-making, not saying that it's right at all, because I did the same thing. I made poor decisions in my life, and I'm just asking for him to get a lenient sentence, to get a second chance. Just like I was granted a second chance at life, so.
Thank you. Sure. Anything else on behalf of the defense?
Nothing else, Your Honor.
Okay. For the state of Ohio, Mr. Geigerich?
Thank you, Your Honor. As much as the pre-sentence report was not completed, the process didn't go through. Prison is the only option in this case. The state of Ohio would just point out that Joshua Brown suffered serious physical harm and that this was part of an organized criminal activity. You know, the court is aware of the facts and circumstances of the case as you heard the trial. And we would ask you to issue a sentence that would be appropriate for the conduct that occurred. Thank you.
In terms of the merger, which count would the state elect to go forward on? Count 2, the trafficking, or count 3, the possession?
Count 2, Your Honor.
All right, so then count 3 will merge with count 2. This court has considered the facts and circumstances of this offense, as this court had obviously the opportunity to preside over the trial and hear all the evidence and facts that were presented. So I've taken all that into consideration. I did order a pre-sentence report investigation. However, the defendant refused to cooperate with the probation department for the preparation of that report, so we don't have the benefit of that. I've considered what's been said here in court today by Mr. Hinton, family members of the defendant. I did receive a letter from the defendant just today, actually, but prior to this hearing, and I've read and taken that into consideration. I've also considered the comments made by the state of Ohio and the recommendation from the state. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29.29.11 of the revised code. As for the factors in 29.29.12, the court finds that the defendant did act as a part of organized criminal activity, that an individual did suffer serious physical harm as a result of the defendant's conduct, and quite frankly, just the facts of this case show the defendant's involvement is much more serious than what we normally see with an illegal conveyance charge. A normal illegal conveyance charge is someone gets arrested, they've got a small amount of drugs hidden on their person somewhere, and they don't tell the jail about it when they're being booked in, and then when they get searched, it's found. That's almost every case that we deal with. But what happened here is the type of, are the facts that people probably typically think of when they hear of this charge. And that was an elaborate scheme that was put together to get drugs into the jail. And this doesn't happen if it wasn't for Mr. Archie. He's the one that has got the drugs, was outside, he was bonded out for this very purpose to do this, and he carried through with it. And the particular facts of this case make this offense more serious than the normal conveyance charge. There's no factors that indicate it's less serious. When I talk about the seriousness factors, I'm talking about the conveyance charge, not the trafficking charge, but the conveyance charge. As for recidivism factors, the court finds the defendant has a history of criminal convictions. It goes back 25 years. He has previously served prison term before, multiple prison terms. He has failed in the past to comply with previously imposed sanctions ordered by courts. No factors indicate recidivism is less likely. This is a felony of the third degree, at least count one as a felony of the third degree, which carries no presumption either way for prison or community control sanctions. But based on the conduct here and the nature of the offense, prison certainly is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions. In determining the sentence that is appropriate, I understand what a co-defendant got. This incident doesn't happen if it's not for Mr. Archie. There are many people on the inside that were participating in this. This doesn't happen if it wasn't for Mr. Archie. He's the one that gets bonded out. He's the one that brings the drugs to the jail. He's the one that attaches it to the rope on the outside. This doesn't happen but for Mr. Archie. His conduct is more serious than Eric Ruskin's conduct is involved in this incident. Therefore, it's the sentence of this court that on count one, defendant served a term in prison of 36 months. On count two, he served a term in prison of 12 months. I'll run those concurrent with each other for a prison term of 36 months in prison. He has credit for 104 days he's already served. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. I further need to advise you, Mr. Archie, that you do have the right to appeal the conviction and sentence imposed. Specifically, if you're unable to pay for the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be appointed without cost to you to represent you on your appeal. If you're unable to pay the cost for documents necessary for an appeal, which would include a transcript of the entire trial as well as any other proceedings we had here in court, those documents and transcripts will be provided for you without cost, and you have the right to have a notice of appeal timely filed on your behalf. I spoke with Mr. Hinton prior to this hearing. I have no objection to appointing Mr. Hinton, and I understand that you would like to have Mr. Hinton appointed to represent you on your appeal. Is that correct?
Yes.
You understand that you're not able to then raise any issues of ineffectiveness of counsel or anything like that?
Yes.
Okay.
Then I will appoint Mr. Hinton to represent you on your appeal. So Mr. Hinton, make sure you at least, you got 30 days to get the notice of appeal filed.
Certainly.
Get that filed and then proceed, go forward from there. I think that covers everything. Is there anything else I need to address for the state?
No, Your Honor. Thank
Mr.
you.
Hinton.
Your Honor, was the defendant given credit?
I thought I said it, but if not, he gets 104 days of credit.
Thank you.
And I don't know if there was a bond that was ever posted, but if there was, it's released.
Thank you, Your Honor.
All rise.